Thank you all for coming. I am particularly pleased to introduce our fantastic panel for this program. I will introduce people alphabetically. George Eichhorn was elected 3 times to the Iowa legislature and served 6 years. For 4 years, he served on the joint House-Senate Administrative Rules Review Committee and was elected chair of that committee twice. George is currently the General Counsel and Director of Compliance for ChildServe, a unique health care provider in the heavily regulated healthcare industry. ChildServe serves approximately 2,500 children in central Iowa with special health needs and employs approximately 1,200 people. He is a graduate of Drake University Law School and Drake University. Chris Grunhaven is Government Relations Counsel for the Iowa Farm Bureau Federation. In this position, she assists members with general legal information, regulatory affairs, and state legislative programs, and is General Counsel for the Government Relations Division. Chris joined the Farm Bureau in 1990. She graduated from Drake University with a JD degree, and she holds her undergraduate degree from the University of Iowa. Chris grew up on a farm in Muscatine County and now resides in Polk City. Larry Johnson, Jr. is Deputy Legal Counsel to Governor Terry E. Branstad. He has served in this capacity since Governor Branstad took office in January 2011. In this capacity, he also serves as the state's Administrative Rules Coordinator. Prior to his current role, Larry worked in the private sector at a Des Moines law firm where he practiced in federal and state administrative law. He received his Bachelor of Science in Management from Crennet School of Management at Purdue University. He went on to Creighton University School of Law, where he graduated Order of the Barristers and served on the Moot Court Board. Julie F. Potteroff graduated with honors from the University of Iowa in 1978. From 1978 to 79, she clerked for the former Iowa Supreme Court Justice Arthur A. McGivern. In 1979, she joined the Attorney General's office in the Criminal Appeals Division. In 1981, she transferred to licensing and administrative law, where she served as staff attorney until appointment as division director in 1990. In 1994, she was appointed Deputy Attorney General, and she served in that capacity until she retired from that job in 2013. I'm going to start with a question first to Julie, who can explain what is rulemaking in the sense of what needs to go through the process. Julie?
Okay. That didn't last long. They both reminded me to use the microphone. The brain retired too at the end of 2013. If you have clients that are concerned about how an agency is applying its law, I think a threshold question is whether they've gone through rulemaking at all. And included in your materials is a memo that I issued in 2010 that happened to go to professional licensing boards who we noticed were posting policy statements on their websites, some of which had never been promulgated in rule form. And a rule, as defined, and you've looked at the definition for years in 17A, is in essence something that generally describes or interprets law or policy and applies generally to the public, or in that case to a group of licensees. When you skip going through rulemaking, you miss a lot of important processes. And believe it or not, I think rulemaking is exciting. maybe that's caused by being retired for a while, but I think it is. And, you know, it starts with a notice of intended action, and the public has an opportunity to come comment in person or file written comments. There's all kinds of opportunities for political input by elected officials. The governor, the attorney general, the rules review committee can all file objections, and there are legal consequences to that we'll discuss in more detail later. But all that political input is completely short-circuited if the agency never goes through rulemaking and simply tries to post its policies or enforce them through contested case procedures. So I think that's your threshold issue, is whether the agency has gone through the rulemaking process that it needs to do so that all the procedures that could politically come to bear on their interpretation or their policy can be exercised.
Thank you, Julie. Why is rulemaking important? Pass that on to...
That's for me to answer. Why is it important? Well, the first thing I would say is that when it comes to rulemaking, the first thing you have to realize that the legislature passes a statute, and in and of itself, it might not be the end of everything. And so it's important to look at how they implement it or how they intend to implement it, and if they have rulemaking capabilities on it, you need to be aware of that process. And if you're representing someone who's concerned about those rules, you have to know the different points at which you can enter and have input on the rulemaking process. They're critical in a lot of different ways because, in my experience, I've seen governors who have taken a statute and turned it a different way, made it mean something different. I've seen agencies who have developed rules that were contrary to other statutes. I've seen what I would consider agencies that have done power grabs, that they have taken on more authority than they would normally have by rules. So you really have to watch how the rulemaking process goes and how the twists and turns happen actually in the process, to be aware of it and also to protect your clients in this process, because they can be adversely affected in a lot of different ways. One of the examples I remember is that one agency developed they decided that they wanted to sell knickknacks and go in competition with other people, and they drafted rules to have a nice little monopoly contract with one provider to do different hats and T-shirts and things like this. Statutes would normally say that they can't do it, and the agency came in front of the committee that I was on and told us that this was educational and it was not for profit or anything of this nature. But clearly there were a lot of people that didn't like the idea that they were now in competition with the state. So in any event, there are a lot of different ways that they can take a statute or take authority. So that's one of the reasons why you really have to watch what happens in the rulemaking process. You probably have a little bit of input on that too.
Is this working? Yeah, rulemaking is very important because then you know what the ground rules are. And when you're in the private sector, unless there's rules that you can look up and figure out what they are, you don't know what you're supposed to be doing. Especially in like in the environmental arena and utilities board arena, it's highly important to have a basic set of rules. So that so the private sector knows what they need to be doing, as well as agency staff. Because if you have management that has an opinion about how something should be implemented, but their field staff level don't know what it is, that's a very major problem for an agency. So it helps to keep everybody that's employed by the agency on the same page. It helps the private sector to know what the ground rules are, and it really helps to avoid arbitrary and capricious decision making by an agency. If those rules are set and established, and what the legislative intent was at the time the legislation was established actually gets flushed out a little bit better in the rules process.
Larry, could you explain now when rulemaking is initiated by an administrative agency, what the governor's office, what the process is at this point?
Sure. And just to add to the first question, though, I would say that rules are important because Even though we do try to make sure rules are interpreted narrowly, I do think the rules do provide flexibility that is delegated by the statute. And I do think that's important because the legislature sometimes, their intent is not to change dates or specific things, that they do allow the agency to make changes with things a little bit more flexible than requiring the legislature to come back that is only in session or should only be in session maybe 4 months out of the year. And so I do think that is important. It is a little bit easier and is intended easier to do that through the rule process. And so that's why that is there for the flexibility. Doesn't mean that it should be taken advantage of or interpreted narrowly, as George said, but I do think that there are certain situations where that flexibility is specifically delegated there. For the question that Susan asked, the current process is a process that was instituted when the governor was here. His first 4 years, Governor Vilsack also pre-cleared rules. That rules come to the Administrative Rules Coordinator, so I have the pleasure of reviewing every single rule that's filed with the code editor. In 2013, that was 322 rules. In 2012, 264. We have decreased rules since the governor, in his first 3 years, we've decreased rule filings by about 500 compared to the previous governor's first 3 years. But we review the rules that are filed by the boards, and then it goes through the notice of intended action process, which you see. Some things that we have changed. The governor has kind of two philosophies that I would say. The first philosophy is to reduce regulation, which I think the numbers reflect that. And then the second one is to involve the public. So the first one, to reduce regulation, is through the pre-clearance process, is to make sure that agencies are narrowly interpreting the statute, to make sure just because something is a good idea, as I stated before, yes, we have the flexibility, but that flexibility has to be specifically delegated in statute. Just because something is a good idea doesn't mean the agency has the authority to do that. They do have to make sure it's specifically stated. If they don't, then that is why the legislative process is there. And we have some examples of the Electrical Licensing Board where the board was inspecting farms, even though it said in code that farms were exempt from electrical inspections. And so Governor Branstad had the legal authority to file an objection to the rule. He could have rescinded the rule, but it was done, or a governor could have rescinded the rule within 70 days of its effectiveness. The governor wasn't in office during those 70 days, so he didn't do that. He filed the objection and went to district court. The district court judge really didn't, I don't think, analyze the objection in his ruling. He kind of just looked at it from a statutory interpretation of the arbitrary capriciousness standard, and he didn't think that the board had the statutory authority to inspect farms. So that was one analysis there. So in the pre-clearance process, we make sure that the board has the specific statutory authority. We also, every rule we look at, because it's supposed to implement legislation, we also look from a policy standpoint. We look to see if it's promoting 4 goals of the governor's, if it's creating 200,000 new jobs, reducing the size cost of government, making #1 schools and increasing family income. So those are things we also look at. And then the jobs impact statement, which is Executive Order number 71. And that's to make sure, although we're reducing regulation, rules do have a point, and regulation does have a point. And the purpose of it is to protect the health, safety, and welfare of the public. But you can do that in the most narrow and efficient way possible. And an example of that is the EPA came out with a rule called the Rice-Meshach rule, which is my favorite rule because it has nothing to do with rice. It's a rule that was dealing with generators, and the EPA said you have to come out and retrofit generators, all these generators, if you have a generator, you have to retrofit it to come up with standards, and it's going to be effective in 2012, and they issued this in 2010. And this would cost small towns hundreds of thousands of dollars, and in fact, statistics came out that it would impact these small towns, the ratepayers, quite about $300 a year. Well, some of these backup generators were only turned on to make sure they actually worked. And so there just wasn't any kind of flexibility whatsoever in this rule, and it just didn't seem to make any common sense that these generators had to go through this process. Were they really polluting if they were just being turned on for an hour every year just to make sure that they were working? And what happened on the state level was the Environmental Protection Commission, which is the state's version of the EPC, or the EPA. They said, well, this is a good idea, so we're going to implement it a year earlier than the EPA. So the governor exercised his authority and rescinded that rule. Then he petitioned the EPA and said, hey, this just doesn't seem like it's the most efficient and effective way. And the EPA looked at it and said, hey, you know, this doesn't make sense. I think we could say, why don't we give you, if you turn it on for about 100 hours, and they gave an hour range, and so it seemed to make more sense. And so that was the Rice Rule. And then the next process we have, the next priority of the governor has been get the public involved. We do that informally and formally. The informal way is when an agency files a rule with me, we say, have you talked to stakeholders? What do they think about it? I always say the nicest compliment I get after an administrative rules meeting is, wow, that meeting was boring. That means that people weren't coming. That means that people were heard beforehand. That means that people were able to have their concerns heard, and things got fixed beforehand. It doesn't mean we have to wait till the last minute. We can do it in advance. The other thing that formally we have is an executive order, stakeholder group, Executive Order 80. Executive Order 80 is where, as government, we ask the private sector to help us, and so it's where we get all impacted stakeholders with one government representative. Usually, we pick a member of the rulemaking authority, and then they pick an issue, usually an issue that can be resolved by rule, and then they will come up with a recommendation and present it to the rulemaking entity. So those are just some of the things that are of the governor's initiatives that I think we're starting now.
How do they define stakeholders and identify?
That's something we rely on both the board and the department head, and it's helpful of people who are involved, but we try to think outside the box, and we try to think of who is impacted, but and I know maybe Chris and George can kind of help on how important it is to be involved, but we try to go from people who do have lobbyists, but I try to have the philosophy of we try to make the rulemaking process. I know probably everyone here is a lawyer. I am too, but I do try to say we want it so just your regular person can understand the rule process and can navigate through it without a lawyer. And so that is important for us too, so that way someone can come to a rules committee, come to a stakeholder group and feel like they've been heard, can present their ideas, and can feel like they've accomplished something. So that's important to us as well.
How do they find out this rule is being considered?
And that's a great question. We have we try to encourage. I know a lot of our boards have email distribution lists of their own, and so we try to make sure. I know I'm on some boards, and so you get everything of theirs, and that although you get a ton of emails, but that is a good way to find out. Then we do have websites. We are mandatory. I'm mandated by statute to come up with a commenting website that hopefully will be launched in the next 3 to 4 months. But each board should have a website, and LSA has a phenomenal website as well.
Yeah, I list some things in my materials just about how you learn about rules. On the legislative website, there's a place that you can sign up and get emails when they get published in the administrative bulletin. You can do that by agency, or you can just get a copy of the whole bulletin, whichever you like, whatever your preference is. And if there's particular areas that you work in all the time, I think you're right. Every agency has a mailing list. I'm on a lot of them, so do get a lot of emails. So, the Utilities Board has a mailing list of all the filings that you can get on. The DNR has multiple mailing lists depending on whether you care about air, water, or solid waste. You can get on different mailing lists with them, or drinking water. So pretty much any agency or the topic area that you want to get involved in, the key thing is get involved early with rules, because once it gets published in the bulletin, a lot of times there's already been stakeholder involvement. They've incorporated a lot of concerns, they've addressed a lot of concerns, or they've decided not to address concerns, which I've had both experiences. But they've incorporated a lot of that into it. So if you wait till the bulletin comes out, you can do the public comment, and sometimes agencies will really, they do consider all of those comments, but you're better off if they incorporate those concerns that you might have early. So make yourself known to the agencies. If it's an area you work in a lot, call and ask them questions and figure out who the staff people are if you have questions along the way. And once they get to know you, then they involve you in the stakeholder groups. If you just sit back and don't get to know or don't ask them questions, then they don't know that you exist to be a stakeholder, to get involved. One thing you talked about lobbyists, and I've seen this a lot, that attorneys that do have represent clients, there are also lobbying rules. And if you're going to advocate on a rule, you're also required to register as a lobbyist. And you do see frequently a lot of folks getting involved in the rulemaking process that don't get registered. But that's just one of the natures of the beast, I guess. But so if you get involved in advocating on a rule, you need to make sure you remember those are the lobbying rules and register. It's all electronic filing. It's a lot easier than it used to be. You don't have to file monthly reports anymore and keep track of your mileage and all those kinds of things now. So it's a lot easier. But that's just one little thing if you get involved in the process to make sure, because even if you're not down at the Capitol all the time, there still are executive branch lobbyists as well that have to do that kind of registration. So, but with the rulemaking process, I don't think we've really talked much about the process itself. I assume a lot of folks here already know what that is, but I don't know if that's an interesting question.
Before we move into actual rulemaking, I had just a couple of comments on stakeholder groups and pre-clearance. When the stakeholder executive order came out, Executive Order 80, I think agencies were a little surprised that they weren't going to be run by them. And when you look at the executive order, an agency head can request a stakeholder group be formed, but it only has one representative on the group. It's really, and this is what I think made it such a good initiative, it's a way for outside interests to generate input and provide it to the agency. I think it's sort of as an alternative to a petition for rulemaking. It lets special interests come in and discuss an issue with only one representative of the agency there. So it's not run by them. It results in a recommendation to the agency, which may then institute rulemaking. So it's a sort of an informal way for people to rally and muster support and come up with good ideas. And that's what I think made it so innovative. While pre-clearance may have occurred under other governors, I don't think it was as robust. And I think it's a very good idea. I'm sure this takes up a ton of Larry's time. But when they first come in the door, before they hit notice of intended action, is really the effective time for what Bonfield would call jawboning. And if the governor has some concern that they're going beyond their authority or the rules ought to be changing in direction, pre-clearance gives him the opportunity to call people in, because he is the big kahuna, and talk to the agency people and get some changes made up front. Included in your materials is a letter I wrote to one of the commissioners on an environmental agency that had some concern that the governor was going too far with pre-clearance. And we took the position that he was not, in fact, going too far, and that gave the governor the opportunity to provide input and get some changes made in an informal way before you start down the notice of intended action path. The only thing the letter points out that could be a problem, and we'd come to some kind of constitutional standoff, is in the unlikely event that there's a mandate by the legislature to engage in rulemaking, and the governor at the pre-clearance stage says no. Then you have a confrontation between two powerful entities that have roles in the rulemaking process. But I don't think we've had any indication that that's happened. And the situation that generated the request and the letter actually resulted in the concerns being ironed out between the agency and the governor's office, although I guess there was one agency member that still wanted to talk about it. So I commend to your reading that letter that talks about the pre-clearance process and how the governor can affect things before they hit the light of the administrative law board.
The one comment I would make is that the rulemaking process depends upon input from the public. And, you know, we've defined stakeholders, but really all the agencies need input from the public. There are certain requirements that are made in the rule system that they're supposed to get that input. So it's not something that it's extraordinary for you to sign up for an agency list or whatever. It really, to get good rules, it depends upon it. And the stakeholder process is one method. You know, there are other methods around the country to get that input. But it really does require it for those rules to be the best that they can be in the first place. So it's encouraged, I think, from everybody expects or hopes that more people will be involved in the process as opposed to less.
We talked a little bit about agency-initiated rulemaking that comes to your office first. What if a group wanted to change a rule or initiate rulemaking? How do they initiate it? What's the process there? Going to your office or going to the administrative agency?
I think the best way to do it is, with 17A would outline it to go to the agency itself. These are, with the several hundred boards we have, 17A outlines the process there for both a petition, rulemaking, a stakeholder group going to the board. I think sometimes we'll hear concerns in our office, but I think most of that seems to be the process for rulemaking, and we seem to have a receptive board. So I think how things have really worked out is most people will go through the boards itself. And I do have to say a majority, and I outlined, and I gave the statistics, and Jack Ewing from LSA is here, and they put out a report every year, and I've encouraged them to put it online. They analyze the breakdown of how many agencies conduct rulemaking and what that number is, and so you can kind of see the top. I put what agencies file the most rules, and number one for 2013 was the Department of Human Services filed 91 rules. Out of 322, 91 were filed by DHS, and my initial intake is that a large percentage of that was statutorily driven. You know, so I for DHS to do that, because a lot of their rules are budgetary at the end of the year that come out of their appropriations. A lot of the cost containments have to go through rules. So that to me was not a huge surprise that DHS was our number one rulemaking entity. So I do think that probably, I don't want to put a percentage, but probably the largest amount of rules come from as a direct response of that year's legislation.
Well, one comment about petitions for rulemaking. It's important to remember that they're just not for new ideas to come up with a new rule, but they can be used to amend or repeal a rule. If there's a rule you think is bad, your client can petition for a rulemaking to do a repeal. There are fairly firm timelines. The agency has 60 days to initiate rulemaking in response to the petition, or deny it and tell you their reasons why. I think it's a very underutilized option for people. I've been in state government longer than I care to admit, and I saw relatively few petitions for rulemaking. And that's too bad, because it can be a very effective tool.
Some other ways to get rules out there is just to talk to the agency itself, because sometimes you don't need to get to the stage of a petition for rulemaking, because if an agency views it as an issue or a problem where their common practices or the ways they do things isn't what the regulation says, there's a motivation for them to make the regulation line up with what they actually do. And so a lot of times you can just have conversations with the agencies, and they may incorporate it into a rule package in the future. But when that doesn't happen, the petition for rulemaking is the backup. There is kind of a sample in my materials of a petition for rulemaking. I tried to find the shortest one I had in my file. So they can range anywhere from a couple of pages. I've seen some, up to 50 pages, and so. But it is a tool that does get used pretty frequently with some agencies. But
Well, have we gone through the process once I think you talked about Julie, the time limits for submitting comments. Could we go through a little bit about the comments and the opportunity to be heard?
And, I think Larry was about to start on that when I detoured to comment on stakeholder groups and I'll defer to someone else who wants to. Maybe that would be a good topic for George.
Well, when the normal rulemaking process starts, they do ask for public input. Quite often they'll have public hearings all around the state. It varies on the agency and what the particular rule involves is how much they're really paying attention. I remember during the smoking statute, when that came out, the rules, they had public hearings on that, and the agency basically said, we're not here to answer any questions, we're only here to listen to your comment, and they didn't say anything to anybody, and they just made a summary document of the comments on what people said, and even then it was probably not real complete. They had it over the communications network, and I remember one site was dark that people were at, and several different things. So you have a lot of different variety there, but they are supposed to they do have several opportunities for comments. You can do it at the agency level, and you can do it in writing, you can do it in person, or you can go to the hearings and speak. These are all ways. I myself would recommend in writing. It's a lot harder to ignore that. And that's one of the things. It's a matter of persuasion when you're at that level, and that's just one of the better ways to be effective, I think. That's built into the process, and that's in the actual rulemaking process. So those are just avenues you should take advantage of.
I will add, just in writing, one effective observation and that I have noticed at the Administrative Rules Review Committee as an ex officio member. Sometimes they can go long, and I know the legislators do really appreciate when groups will present their comments in writing before. That's if the topic is effective representation and rulemaking. The legislators, they do a lot of homework beforehand. They like to be really prepared going into the meeting, and I have noticed going into the meeting, they really like issue spotting before, and so if they get a couple emails or a well-written letter outlining the concerns before, I have noticed how the discussion is, it's really a well-informed discussion when they're receiving the comments beforehand, versus here's my 4-page letter, I'm going to hand it out to you right now. If you can hand it out to them before, send it to LSA. That's probably the most effective way.
Well, I would probably add didn't really address the Administrative Rules Committee process at this point of contact, but there's a lot more ways you can be effective at that committee. That's just some of the thoughts there that you gave, but I didn't really address that. I think we might get to the Administrative Rules Committee a little bit more, but yeah, there are a lot of different ways you can become effective at that process, and we'll probably go through those a little bit more later.
Is that part of making your record if you are going to ultimately appeal the enactment of a rule on the basis that it's arbitrary, capricious, or beyond the statute?
Well, you're making a record at the agency level most of the time for when you're going to be contesting rules. You can make records at the Administrative Rules Review Committee, and because one, they do take a nominal set of minutes that is publicized, but they also do have copies of all the information that people can submit. Haven't really known that to be the record that you're usually looking to for contesting administrative rules. It's usually that's usually at the agency level what you're producing there, but you are making somewhat of a record when you submit your letters or those kind of documentation to the Administrative Rules Committee.
While the comments are useful on judicial review, I think it's important to remember it isn't rulemaking on the record, and you can come along 2 years after a rule is promulgated and challenge it. It isn't something subject to waiver if you didn't make oral comments or submit written comments. And George raised a good point about agencies just not engaging with oral comments at all, and that's unfortunate. There's an urban legend, I'm not sure if it's true, of an agency plunking down a tape recorder and then leaving the room and letting people comment into that. That's horrible. At its best, there's some give and take, and I think an oral presentation can be effective, even if it just supplements something that you've done in writing.
Can you go through the process, George? You were talking about the Administrative Rules Committee and the process as it goes through your opportunities to impact the rulemaking.
Well, one of the steps in the rulemaking process is to go in front of the Administrative Rules Review Committee, and that's a joint committee of senators and House members, equally balanced between the Senate and the House. And it's politically determined. The majority party in the Senate will determine 3 members, and the majority party in the House will determine 3 members. So it can be political, but it's a pretty unique committee, and you probably should be aware of the statute before you go in front of it, because they do have some peculiar voting requirements and rules on that. But in any event, the first thing I'd say about when rules go in front of the Administrative Rules Committee, you are talking about a separate stage in the process and a very big way you can influence things, because this is a much more political process than your rulemaking normal steps. The normal steps in front of the agency will get you so far, and definitely the board is one jury, if you will, about who you want to affect. But in my mind, the Administrative Rules Committee is a second jury that you can have a hearing about the rule, and you should pretty much approach it that way. It's not a normal legal procedure in that you've got legislators in control of it, and each one of them is a decision-making person, and legislators are used to getting input from people, from their constituents about issues. And it's not norm to wait for a hearing for them. So, for instance, it would be typical for people to call me and say, George, we have an administrative rule coming up on this day, and here's what I'd like to tell you about it. This is a good rule, it's a bad rule, and the reasons why. So contact with each individual legislator is not unusual. So that's one way you influence it. If they know you, it's usually easier to call somebody or email them if you know them. If you don't know them, then I would definitely recommend you write them and you can write them directly. You don't have to go through the administrative rules, the legal staff there, which you can do. You can send it to Joe Royce now, who is the attorney for the Rules Committee, and he will distribute it if there's enough time. But you can also write directly to the committee members. All of those I view as effective advocacy. You get your issue to them a little bit better. In any event, with enough time, the legislators will review it and be prepared. Quite often, the decisions that are coming up in front of the Administrative Rules Committee are discussed by the different members of the committee before the committee meeting. So they've already got a pretty good concept of which way they're going to go on any particular rule, whether they're going to object to it, whether they're just going to make a few statements about it or not. But they're typically decided, for the most part, before the committee meeting is done, or before it even starts. In any event, you can do this pre-meeting contact, which I highly recommend. You can go to the committee meeting itself, and they have you sign in, and you can speak. The Administrative Rules Committee, they go through an agenda of rules that they have asked an agency person to be present at, and they will ask for public comment. Now, obviously, it's not unlimited comment, but it is an opportunity for most members of the public to say something if they would like. Their agenda gives it a little bit of a time frame that's flexible. Sometimes they go considerably longer. Sometimes there's a lot more controversy there. I'm not sure what the chairs do now. I would typically, if we got too long, I would normally say, well, we're going to be done with this rule at this time, and we'll come back at 5 o'clock for that rule. And that would normally stop most of the comments from coming in after that. So, but that's a possibility. But you do have possibility to actually do an oral presentation at that time. Again, most of the time I think that's not the most effective way to present your arguments about the rules. I think the pre-contact is more important. There's also a lot of other informal ways you can have input to it. There is an attorney for the Administrative Rules Review Committee that most people funnel comments through, and that's just one way you can do it. Alerting him, or if it becomes a woman, her, then alerting them that there's a controversy is probably pretty important to do, and the earlier you can do that, the better. Because, one, their role is to help the legislators in this process, and they would rather alert the legislators of a controversy before the meeting than to have one surprised upon everybody. So alerting them that there's a controversy is also helpful in the process. It also may affect the material that goes out to the legislators, be it the administrative, the digest, which is a little summary of the rules and what a little of the rules that are more controversial or more important, whatever they're coming up. The Legislative Service Agency prepares this report, and you might be able to influence what's on that report if you get in contact with the attorney for the Administrative Rules Review Committee. That's another avenue that you can use to try to influence the rulemaking process. I haven't seen that done very often, but I know it's a very viable thing to let the attorney for the committee know. So those are just some of the avenues that you can have input at the Administrative Rules Review Committee that if you're advocating for some position on the rules, those are highly recommended.
We've gone through, you go to the Administrative Rules Committee, and what action do they take and when? Well, first, the Administrative Rules Review Committee has a role in every rule that comes up during the process. It comes to the committee. They can review it a little bit more thoroughly by asking the agency to be present, or they can just put it on a list and say, well, this is one of the rules that we're not asking the agency to be present for. That's one way that they're going to look at all the rules as they go through. There's another avenue is that one of the legislators can ask some rule to be put on the agenda at any given time.
So if any particular legislator, more often a constituent of the legislator, has a problem with the rule, this legislator can ask to have that rule reviewed by the committee. That used to be done at the discretion, I think, of the chair, but I believe those rules have been changed, the committee rules have been changed so that other members can, the vice chair can also put something on the agenda. It's an informal rule, basically, of the committee that any legislator can ask, and the chair will normally put it on the agenda just from the asking by the legislator, but it's not openly within the committee rules. Regardless, you can have these rules at different times come up, but once they're in front of the committee does have a lot of different powers. In the process of going through, they can say, we think there's a problem, we're going to object to it. They can also refer it to the legislature to look at. They have powers to ask for a regulatory analysis of it. They can suspend them in certain instances. They have now some prerogatives on emergency rules on whether or not they want to object to how those are being, some of the requirements there. This is all probably in the material that is available. But in any event, those are formal powers of the committee, and then the committee has a lot of informal power too. Quite often, the committee, in the past at least, has registered some concern about rules and not done formal things, but directed the agency informally, either to work with the regulated industry. That was quite often done where we said that we thought there was better, that more communication back and forth was important. Sometimes we asked for informal regulatory analyses where they would look at the costs a little bit more and the benefits more. Generally, the agencies would take comments from the Administrative Rules Review Committee to heart and respond to them, and they would normally try to keep the Administrative Rules Review Committee on their good side. Similarly, the governor's office, they don't normally like to cross. I think I only saw one board cross the governor's office suggestions in my 4 years on the committee. I don't think they won the battle. In any event, it's a matter of there's a lot of informal things that can happen just by having legislators on your side of the issue. But normally you'd like to have some formal action by the committee, be it the objection, which changes legal burdens if they try to enforce it. For instance, most agencies would be very reluctant to pursue anything that had an objection on it from the committee. Suspension of the rules, that's usually a thing that agencies don't like to see happen when they come around. So typically they would be, and there are a couple different kinds of suspensions that the committee could do. What I would say is look over the material, look over the statute, make sure you have an idea of what you want to accomplish before you go to the committee, and that would be what you would be arguing for. And when I would, if I were to argue it in front of the committee, I would basically try to find a couple of legislators who I could perceive as champions, and I would try to know how the committee is going to vote before they got there, to realize how successful I would be in my particular advocacy of the rule. Is that pretty much how you do it?
With respect to an existing rule, can that also be called before the Administrative Rules Committee?
Yes, any rule can be called in front of the committee by, like I say, usually a legislator would request it and the chair would put it on the agenda.
So that could be a rule that's been in existence for 5 years?
Yes, 10 years, whatever, any kind of rule.
They get listed on the agenda as special review, so you know that those aren't new rules that they're looking at. And Joe usually highlights those sometimes.
It's usually not to congratulate the agency on what a fine job they're doing.
Usually not, yes.
And George brought up the possibility of a committee objection if you're planning to dig in for the long haul and challenge a rule in court. There are certainly advantages to getting an objection. It it takes a vote of the committee to get them to object, but then the burden of proof shifts, and there's a possibility of getting attorney fees if you prevail on judicial review. Other places where you might get an objection lodged, the governor's office can object, although I think that's fairly rare, other than the recent showdown with the electrical examining board. The attorney general has the power to object, but as far back as I can remember, which may be before some of you were born, he objected once, Tom Miller, to a rule. I think that was sometime around 1980. And part of the reason may be that there are other ripple effects if the attorney general objects. It's the attorney general's constitutional and statutory duty to defend agencies. And if you're going to file an objection, then we're going to have a conflict of interest, and we can't defend them when they're litigating with the burden of proof bearing down on them. They'll have to get outside counsel, and that'll be at taxpayers' expense. So while the numbers might be with going to the governor's office to ask for an objection or the attorney general, I think it would take a lot of thought before the attorney general would actually object to his client's rulemaking.
And the governor has objected to one rule and then rescinded two. And when rescinded for us, I believe rescinded is used in 17A, but we often refer to it as veto because it has the same effect. And I don't know if the attorney general does not have that authority. I don't believe the rules committee has that either. So I believe the governor is the only one in 17A that can rescind a rule.
But do I understand you to say that if the Rules Committee files an objection to it, even if it's an existing rule, then the burden shifts when you go to court? So that's obviously a powerful thing, but how often does that happen, George?
Not very often in that scenario. Objections are normally made during the rulemaking process, but of course the large number of rules that come in front of the committee are during the rulemaking process, not the special reviews are the rare critters.
I guess, and George can correct me if I'm wrong, that if the committee's contemplating an objection, that word may get to the agency in advance, and they might make some helpful changes to avert getting an objection filed.
Yeah, the different things with, there's objection, there's the 70-day delay, there's the session delay, and there's the general agency referral that happens. And the other interesting thing is you have to look at the makeup of the committee. You know, it is 5 senators and 5 representatives, but party makeup kind of affects some of that too because of different philosophies toward different rulemakings. And so the objection takes 6 votes. And so it's a little bit easier vote-wise to get that depending on the makeup of the committee. And then your 70-day delay on a rule, that only applies if the rule hasn't taken effect yet. Because if the rule's in effect, a 70-day delay doesn't do you any good, obviously, or a session delay doesn't do you any good. And so those two delays of effective dates, essentially, those take place when you're actively in the rulemaking process. Or the objection, the rule still goes into effect. And so the objection, it doesn't do anything to stop the rule, it doesn't change the rule, that rule goes into effect. It just changes the burden of proof rather than, it basically takes away the agency deference that you see in normal administrative law cases and takes away the agency deference. And so then the agency is put on kind of a level playing field to try to defend the rule or challenge, I should say, the plaintiff is then put on a level playing field in challenging that rule and not having to get over that high burden of the agency deference and trying to get past that. So that's where the objection can be used at any time, is because it doesn't stop the rule going into place or being implemented or anything else. It just changes that burden of proof.
We've kind of fast-forwarded into rulemaking, but I think it might be wise to spend a few minutes talking about emergency rules. And this governor has done an effective job of cutting back on those. It's too bad Joe isn't here. I think for a number of years they did what was called double barreling. You'd file an emergency rule, and at the same time you'd start a full rulemaking process. And I think there was some practical appeal to that, because the rule's in effect, and then by the time people have mustered their forces and gotten upset about it, you're in the middle of the full rulemaking where there's an opportunity for comment, for objections, and all the other procedural powers you can bring to bear. The problem with emergency rulemaking that I have of double barreling is that I think it breeds cynicism. Maybe not to the same degree as plunking down a tape recorder and letting people talk to an empty room, but I think when people see the rules are in place, they're already effective, but hey, you can file comments if you want. I think it discourages people from feeling like they're really participating and have a chance to change things. So I've never been much of a fan of emergency rules. And I noticed when it got passed, I didn't notice it at the time, but now, what was it, House File 586, you can't, it used to be left to the agency to decide whether for good cause notice and comment was unnecessary, impracticable, or contrary to the public interest. Now that might seem like a high standard, but I can tell you a lot of agencies didn't have any trouble getting there. And with House File 586, that determination has shifted to the Rules Review Committee. If there's no authority in the legislation itself to do emergency rulemaking, and occasionally the legislature includes that, then you need a vote of the Rules Review Committee, and they'll make the determination of whether notice and comment period is unnecessary, impracticable, or contrary to the public interest. So that should drastically reduce emergency rules, and I think that's a good thing.
And it has. In 2010, there were 113 emergency rules out of 427, and then in 2011, out of the 310 filings, only 60. So we went from 113 emergency filings down to 60, and part of the reason was that was the year that our session ended on June 30. And so a lot of the emergency rules came to again, DHS has a lot of rulemaking authority because our budget starts on July 1, and so they have to do a lot of things to get their cost containments, and they get the emergency rulemaking authority in statute. And then what Julie was referring to, that law came into effect in 2013. So that's a relatively new rule. That's both very good, as you can tell. The second priority of the governor is to involve the public, so emergency rulemaking authority really doesn't match with that, and so we try to decrease that as much as possible. And so we were doing that already, but it is inefficient in the sense of I believe the Secretary of State's office is trying to change their fax number and some numbers right now, and they don't want to put it out for notice and wait all the whole days and requirements, so they have to then put it on the agenda for October, get the emergency rulemaking authority, because that is something I think Julie was correct, where agencies used to use the part of the statute that said nobody would really care about this, and they kind of used it too much. This is actually, I don't think the public really would care about the fax number or the address, and if they would, but we can talk. So those are things where those are some issues that we're running into there, but that happens relatively few. That it is good to really have the agency prove the burden is on the agency now to show why the public should not be involved up front, which the burden always should be. And so the 2013 legislation just really emphasized, no, the burden is on the agency to do that, and it has worked out. I think it's been, besides the statutory, the legislative authorized authority for emergency rulemaking, which is mostly given to DHS for their appropriations. I would say maybe less than 15 agencies have gone and received emergency rulemaking authority in the past year, which is even down than the 60. So we've cut it down from 50% from 2010 to 2011 now, even further.
Well, I had served during those time periods where I think every legislator had concern that agencies were doing emergency rules, knew they were going to do some kind of response to it sooner or later, but I would say that the statute that they came up with in 2013 was an interesting statute to look at. Not sure if it's constitutional, throwing the legislature back into an executive branch activity, but it was a logical answer to the problem, because a lot of the agencies, their emergency was self-created. They would wait until the last minute and say, oh, well, it's impractical now, and they would issue rules right before, they wanted something to go into effect. So it was something that was quite abused, and I think the governor's office has done a pretty good job of reining that in, and this statute has definitely changed things.
Some recent decisions that perhaps should be discussed now. One is Iowa Farm Bureau Federation et al. Versus Environmental Protection Commission. Christina, are you familiar with that case?
No, yeah, I did not put that one in my outline. Yeah. Yeah, it was an oversight. It wasn't in my outline. The Iowa Farm Bureau versus EPC case just came down earlier this summer, just a couple months ago. And basically, the issue involved in that case, it was a challenge of a rule that was adopted by the Environmental Protection Commission, and the basis of that challenge was that the board is improperly constituted and that the members had a conflict of interest on the board. The EPC requires 5 votes in order to take any action. So if there's somebody missing that day, it still requires 5 votes. They did change the rulemaking that if there were 2 missing members, then they could go down to 4 from governor appointments, because sometimes if somebody resigns, they don't have and don't get somebody reappointed, the board may be a little bit smaller, but it's normally a 9-member board. And in this instance, there was a paid advocate that served on the board. There was someone who was an out-of-state resident at the time the vote occurred, and our organization challenged that rule on the basis that the board is improperly constituted because of that. Basically, the ruling said that rulemaking is a lot different than contested cases, is the bottom line, and that when you're looking at rulemaking, then it's just like a legislative body, and there can be conflicts of interest. The only time, and it's a very, very high burden to meet, is that if you have an unalterably closed mind, and that would be the only time in which a conflict would raise to the level of being improper under Chapter 17A. And so it established new rules of appointments and who can be appointed on boards and commissions and who can vote on rules and not have to recuse themselves at this point. So under the new ruling, only those folks that can be proved that they have an unalterably closed mind and wouldn't listen to public comment, essentially, would be disqualified from voting on a rule.
Christina obviously worked with the Farm Bureau on this case, but our office defended EPC. And I have to congratulate the Farm Bureau on their strategy. There were 9 members on the EPC. The vote was 6-2 in favor of these very controversial water degradation rules, and 1 person abstained. So if you can knock off 2 for a conflict of interest, you didn't have enough votes to sustain the rules, which I'm sure was an outcome that they had hoped for. But just to put a little more meat on the bones of the analysis of the court, the challenge to the 2 members on EPC, both of whom are no longer there. One was Susan Heathcote, who worked for the Environmental Council. And none of the commissioners are full-time employees. They all have other jobs. And what I think is kind of interesting and kind of sets the stage for the court's ruling is that 4 of them, I guess 5 of them, have employment ties that are mandated by statute. 3 must be actively engaged in livestock and grain farming. So they're going to have some environmental notions, strong policy views. 1 needs to be the manager of a manufacturing company. 1 must work in finance or commerce, and the other 4 are open in terms of their employment, but they must be electors, which means you're eligible to vote in the state of Iowa. Susan Heathcote was challenged because as a member of the Environmental Council, she'd been part of the group that filed a petition for rulemaking, as did the Farm Bureau and groups associated with them. And she advocated to increase environmental protections and have a stricter rule on water degradation than the other petition. The commission ultimately came up with, I'm not sure I could call it a middle ground, but it's something closer to what the Environmental Council wanted. And her affiliation with the Environmental Council was always known. And obviously she had strong environmental concerns, which I think are kind of balanced out by the fact that you have livestock and farming interests represented on the commission. And the court, as Christina indicated, said in rulemaking, having a strong policy view is not a conflict of interest that's disqualifying, unless by clear and convincing evidence you can show that the action was undertaken with an unalterably closed mind. And as you can imagine, that's going to be kind of a tough burden to carry. The other person, Carrie LeSueur, was spending part of her time in Montana, where her husband, I think, had a teaching position. And she's required to be an elector, as other members of the commission are, but as part of the motor voter law that was passed at the federal level a number of years ago, when you go in and get your driver's license, they offer you the chance to register to vote, and she registered to vote in Montana.
She also voted twice, too,
Okay.
in Montana.
All right. So she really wasn't an elector any longer, and for that reason, the Farm Bureau thought she should have been disqualified. Her vote didn't count. You're down below the 5 votes that were required. But what was at issue in the case, I think, is the de facto doctrine. And I can remember talking to our environmental division head, who told me when the challenge came in, what the issues were, and I said, you need to look at the de facto doctrine. It dates back to early statehood, as the court pointed out, in Iowa and other jurisdictions, and into the common law of England, and essentially says that even if an officer has some legal infirmity in which they may not be qualified to serve, you uphold the official action, and the remedy is to remove the official. So attacking the official shouldn't be a collateral attack on actions taken by the commission. There was a dissent. 3 justices dissented on the de facto issue, where they thought being an elector was central enough to the qualifications that she should have been disqualified and that vote should not have counted. But the majority found, and I think correctly, that the de facto doctrine applied, and whether or not you're registered to vote in Iowa didn't go to the heart of these rules. And as some background that may have affected the court, there had been a regulation enacted at the federal level in 1983 requiring water degradation rules be done state by state. And Iowa didn't tackle it until 2007. There had been a significant delay. They spent 3 years going through rulemaking, far more than the notice and comment required by 17A. So they had public hearings. They went through this whole process to wind up with a 6-2 vote, 1 abstention. I don't know why. And then the Farm Bureau challenged 2 of them, which would have gotten them below the 5. But I'd commend it to your reading just for the standard of proof that if you're going to challenge a rule and you think somebody had preconceived notions or strong commitment to policy positions that was a decision maker in the rulemaking, you're going to have a tough row to hoe.
When I read this case, I came off with a couple of different opinions about it. One, of course, is I thought it was interesting that you have a rule that you don't like and you attack the commission on forming the rule, not attacking the rule itself necessarily, but just the commissioners on it. So I thought that was an that's one interesting issue that I thought. The other thing I thought about it is that I was a little disappointed with the ultimate ruling, because the standard of proving somebody's got an unalterably closed mind basically takes any kind of argument away, as far as I'm concerned, about what I would normally want to be a deliberative process by a board. And I understand that some of these boards are made up of people with special knowledge and backgrounds, but I thought it was a little bit disturbing to think that you could have somebody well beyond just, what I would consider passionate or knowledgeable about an issue. And I was wondering what what the standard, if this was a judicial decision-making process, would we have anything close to this or not, this unalterably closed mind. And I thought that this might ultimately affect your rulemaking if you have that kind of flexibility for board members and commissioners. I could not understand how a requirement for being on the board being an elector and having a person move out of state and not be an elector was not a big deal. To me, that was a pretty big deal that should have stopped this person's vote from counting. Didn't overturn this rule by that fact, but I found that very troubling that we would go to the de facto doctrine to allow the decision to stand when one of the people clearly wasn't qualified in my mind. So there were some troubling aspects about it that way. In the long run, I mean, I think that, it will have an effect on administrative rulemaking and then the composition of boards, and unfortunately, I think it will make it more political as opposed to less political. And in my mind, administrative rules are becoming more and more important into the practice of law and affecting people. And I would prefer to see it less political than more political. And unfortunately, I think that this ruling pushes it that way. The other thing I thought was very interesting is that, if I remember correctly, the Farm Bureau tried to get more information about this commissioner's background and whether or not they were a paid lobbyist and this sort of thing. And if I remember, they were cut off on that effort by the district court. And then there was a question of whether or not this was a paid lobbyist at the Supreme Court level, but they could never get to that information to be able to prove it. If I remember something like that.
Actually, the court, I think, in the ruling said that she was a paid lobbyist, a paid advocate.
See, I didn't see that.
Yeah, the issue on the discovery was what was her role within the Environmental Council. Was she actually forming the public comments that the organization was submitting? Those kinds of things that normal lobbyists do is write public comments and help with grassroots efforts and those kind of things. And
so being a paid lobbyist wasn't important enough, huh?
Correct.
Okay, it's interesting because, again, it's a matter of it introduces a lot more politics into the process, and I think the public would prefer the non-political process more than the political process.
I'm not familiar with the de facto portion, but my question then is, obviously it applies after the fact, and you're looking at an action taken by a government official who was not qualified at the time. Was there a challenge to her sitting and deciding the rule before the rule was enacted, and would that have made a difference under the doctrine?
She kept it a secret. No one knew that she moved because she still had a home here and she would fly back for meetings. About half of the meetings after she moved, she did it by teleconference. And so that it wasn't disclosed publicly until she sent out, and quite frankly, we learned about it because it was in our newsletter that she sent out organizationally, and otherwise we wouldn't have found out that she had moved.
Can you respond to that?
Well, it wasn't widely known. I don't know that she kept it secret for any malicious reason. I think people offered her the chance to register. She did.
I
didn't think about it.
No, I don't think it was malicious. She just didn't publicly announce it.
Right, and the vote was over before the challenge, and I believe she resigned. The Farm Bureau raised that as a qualification problem, that she could no longer sit on the commission, and she resigned. But by then the vote was over.
Yeah.
So it really is a case all about whether those kinds of disqualifying factors mean you go back and invalidate the official action itself. It's a long opinion to wade through, but I commend it to you if you're fascinated by the de facto doctrine. Because there are a number of cases are discussed by Katie, who wrote the majority, of where a minor factor, and he considered this minor, usually George did, whether that should upend official action that's been taken.
So as a next thought, if in the future you're looking at a board which may not be a friendly board, would you want to attack the qualification before the rule? Would that get you outside of or above the de facto doctrine? What's the strategy?
rule. But it may make some of the, Senate confirmations more politically engaged, because you no longer can challenge an agency or an appointment on a person's particular vote, because if they don't decide to recuse themselves from the vote, and you just have to put your efforts into other parts, because I think this angle of challenging a rule has been foreclosed now by the court.
Well, I don't know that it's foreclosed.
Well,
I mean,
it is a really high burden.
One of the examples Katie gives in this extraordinarily long opinion is that a police officer or an officer who didn't get properly certified to operate breathalyzer equipment, that goes to qualification, but it pretty well undermines the test result. And that you wouldn't allow the de facto doctrine to say that the test result stands, because that's kind of pivotal. That's not his language, that's my my take on it. And then other qualification challenges are more minor, like somebody who didn't properly execute the oath of office isn't qualified, but would you upend all the official actions that were taken by that person for that reason? And I think most people would agree, no. So the question, I think, in the litigation is, where did Carrie LeSueur's registering to vote fall? Is it closer to not being certified to operate the equipment, or failing to properly execute the oath of office? It was somewhere in the middle, and I guess for the majority it was close enough to be covered by the de facto doctrine.
Well, my point was not at confirmation, but between confirmation, obviously, sitting on the board, and the promulgation of the rule. Had you been able to attack it at that point and ask her to be taken off or disqualified at that point? Would that have been a possibility? Obviously they didn't know, but had they known? Just asking
one of the problems with contesting rules, and if you're going to try to move to get a commissioner disqualified before a rule is made, or this sort of thing, is that a lot of you would not generally, a regulated person or party is going to have a long-term relationship with an agency. This agency is going to affect their business for quite a long while. You wouldn't normally seek an argument and confrontation before something significant happened. And so it's very, very difficult to envision when you would want to infuriate the whole board for this purpose. So a lot of the things, the balances in administrative law really don't work very well, and that's one of them, I think. The other ones that come to mind right off the bat is changing the burden the burden of proof in legal cases really doesn't make much difference to when you're talking about agency action for economic benefits. You're not going to take them to court if they don't give you the money. You're going to look to the future to try to get benefits from programs. Some of these things. So there are some things that are out of sync, and that would be one of them. I just don't think you probably would challenge a commissioner unless you were never going to deal with them again.
I'd venture a guess. I'll put words in Christina's mouth. Carrie LeSueur was well known as a strong environmentalist, and if they had known that she registered to vote in Montana, my guess is they'd have brought it up before the rule passed.
Could have been, yeah.
Because it would have caused her to resign when they did bring it up.
Thank you. There have been a couple other decisions that have come down. I'm going to skip Planned Parenthood and first speak of Iowa Medical Society versus Iowa Board of Nursing. Could someone speak to that decision and its relevance to rulemaking?
Yeah. I mentioned to George that we should discuss this case. It came down in 2013, and it's at 831 Northwest 2nd, 826. 831 Northwest 2nd, 826. The reason I think it's interesting is that it's a delegation of rulemaking authority that came with some vague terms and some unclarity. Sometimes the legislature requires people to work together or have some consensus when they go through rulemaking. If it's legislated, it's probably not going to be easy to do. And in this case, the Board of Nursing had authority to define the practice of nursing and define certain procedures that nurses could do, but it came with a statute that says that they need to be recognized by the medical and nursing profession as appropriate for the practice of nursing. And then the question, of course, came up is who speaks for the medical profession? And are you going to be able to get doctors and nurses to agree on what nurses could do? The procedure at stake here, and I can't even tell you the technical medical meaning of it, is fluoroscopy. And nurses supervising the technicians that perform it. And I think it has to do with infusing some chemicals that go through the system and they help in diagnosis. How's that for a very lay understanding? The nursing board, this process had been going on in some hospitals in Iowa for almost 20 years. And the nursing board embarked on a rulemaking to formalize that and say that nurses, not all nurses, but advanced care practitioners, could engage in the supervising of fluoroscopy at some hospitals, which they had already been doing. When it came to getting the medical profession to agree that they recognized this as something nurses could do, it was not unanimous, let's say. And as the rulemaking progressed, the professional organizations on the practice of medicine involving doctors kind of all came out of the woodwork. The Board of Medicine opposed it, the Medical Society opposed it, the Osteopathic Association opposed it, and the Society of Anesthesiologists opposed it. In fact, I'm kind of at a loss to think of a medical professional group that's not recognized here. But the nursing board proceeded, and what they had as their evidence of medical profession recognizing that nurses could do this were statements from various doctors and the fact that somewhere between 15 and 20 hospitals had credentialed the advanced care nurse practitioners to do this. So there were some doctors who supported it. And the legal question kind of became, is this sufficient to say that it's recognized by the medical profession when all these professional groups who intervened were opposed? It left, I think, the court with an odd issue of law and no authority. And they were actually, they looked back to an opinion by Richard Turner. Are people here old enough to remember Richard Turner? There was actually an attorney general before Tom Miller, and it was Richard Turner. And there had been an opinion issued years and years ago, in the 70s, saying the statute doesn't say that any particular medical professional organization is required to give their approval, and sort of left it open-ended for the nursing board. So it comes to the court, and the court's left to decide. And I guess they decided they had enough doctors. They didn't need those professional associations to concur, and upheld the rulemaking. There is no discussion, and I think this is significant too, of a policy matter of whether nurses can or can't perform this. Partly because they, like me, probably don't understand what fluoroscopy is. But courts don't get into the policy-making part of it. If you've got the rulemaking authority and you've met the statutory requirements and you go through the procedures, they're going to defer to the agency. So once relying on the Turner opinion, they concluded that it didn't matter if the Medical Society opposed it, or the Osteopathic Society, or the Board of Medicine, or the anesthesiologist opposed it. They had enough doctors to say they had a buy-in by the medical profession. So that's why I think the case is actually interesting.
Also has the benefit of having a dissent, if I remember correctly, which administrative rules shouldn't normally be that controversial, but they seem to have been gathering up that lately.
Well, the most recent case is Planned Parenthood of the Heartland versus Iowa Board of Medicine, and that case is, I believe, included in the materials for today. In that case, Judge Farrell determined that the procedure had been followed, and again, based on the Farm Bureau case, the fact that there was an obvious bias in the board as to the abortion issue, that did not disqualify them from making a determination on this. Would anyone here like to comment on that case? Obviously, it is It's a district court opinion. The ruling has been stayed, which would have allowed the telemedicine to go forward. And Julie?
I can offer some opening comments. This was a separate handout because it's exceptionally long for a district court decision, 40 pages. And why I think it's interesting is, again, it's a court leaving the policy to the rulemakers. Judge Farrell's a new judge who was formerly in our office and formerly an ALJ in the Department of Inspections and Appeals. And the telemedicine issue has been all over the news. Concerns the prescription of medication that causes a spontaneous abortion, and the somewhat controversial process of allowing a doctor to interact with the woman by video conferencing and dispensing the medication remotely by allowing a drawer to pop open, and then the medication is administered on site by other medical personnel. The rulemaking, and I have to congratulate the board, whatever side you're on the medicine side of this, I'm kind of keeping this neutral to a rulemaking discussion because I'm sure we all have strong views about the merits of it. The board had a complaint that was filed, I think in 2010, against a doctor for performing the little authorize the drawer to pop open and the pill pops out, and remotely participating in these procedures. They investigated and they declined to bring a disciplinary action against the doctor. The composition of the board changes, and that matters, who is on board. So if you yawn your way through the list of appointees, you really shouldn't. It matters who's on it. They changed direction, which they're entitled to do. What would have been terrible is if they had changed direction by disciplining another doctor. They didn't do that. They went through rulemaking, and there had been no rule that addressed the process of this telemedicine abortion before, so they embarked on a rulemaking, which was exactly the right thing to do. And they invited public comment, and there was a lot of it. I remember I popped in for some of it. The comment was in the auditorium of the Wallace building. There was no tape recorder sitting there abandoned. There was interaction. I think there were 28 people who appeared with oral comments, and they had over 200 and some who submitted written comments. And then they reached their conclusion, and they enacted the rule that required the physical presence of the physician. So they didn't ban the procedure, they banned the telemedicine portion of it. And if you read Jeff's ruling, Judge Farrell, excuse me, he's very methodical, and it's a well-written ruling. And at every juncture where the question is whether they were tainted by politics or an improper purpose, he leaves that to the board to decide. There was no question that they had the rulemaking authority to do this. There was no question that they went through the proper procedure, although there was some flap about how quickly they embarked on this. But he very pointedly goes through the arguments and leaves the policy calls to the agency. And that, I think, is what you can take away from all three of these rulemaking decisions. The people who engage in rulemaking on these boards have enormous authority to affect people's lives, to promulgate rules, to punish people who violate them. Nobody voted for these people. They're appointed by the governor, they're subject to Senate confirmation, and they have an enormous amount of authority. So it's important that people pay attention to who's appointed to these boards and commissions, and that you participate, get your clients to participate in the process of rulemaking, because critical social decisions are made through that process. Right now, the decision is on appeal, and just the other day in the paper, the court issued a stay. Jeff's decision, Judge Farrell's decision, upheld the medical board rules, which would put an end to the telemedicine process. He specifically gave the parties 30 days for the decision to take effect, so they had time to get a stay from the Iowa Supreme Court, which they did. So that procedure will continue until it's taken up and decided by the Iowa Supreme Court. And I predict that they too will stay out of the policy questions and only answer the legal questions that are brought.
Yeah, a couple of the things that I took from reading this particular decision, again, the attacks on the rule were, there was some about the bias of one of the board members, commissioners, whatever, and that one, of course, didn't work here, and it was it was, as far as I think the district court was concerned, it wasn't as solid a case as what the Farm Bureau had in their attack against people. So again, that proved unsuccessful. They also tried to argue that how quick the board went through the process showed a bias or somewhat of a problem that way. And similarly, they followed the statutory guidelines, and so that was satisfactory for the court's purposes. So there were a couple things there that I thought were, again, unsuccessful attacks of going to the rules. The other thing I thought that was nice about this particular decision is when you're attacking agency rules, there's a nice laundry list of things in the statute that you can look at. And some of them are pretty vague terms, and the judge went through this one and said, well, subparagraph E, subparagraph F, those kind of things, and said, this one really doesn't mean much more than arbitrary, capricious, or whatever. So he addressed different statutes, different parts of the statute, and basically gave a little bit of an explanation to them where they're, where they would be applicable, which is nice to see because the statute is, it's hard to say what some of those are really trying to accomplish. So those were some of the things that were of interest, I think, from an administrative law perspective to me when I read this decision. The other thing that's underlying the whole bit, I think the whole decision here, and what makes this really crucially important, is that telemedicine, for somebody who works in the healthcare industry, telemedicine is a huge area, something that's growing considerably across the country, is happening in every state now, not necessarily for this particular procedure, but for a lot of different purposes, and it becomes critically important for the delivery of healthcare, particularly some of the specialty fields that you wouldn't necessarily see in all your rural areas. So it has some policy overtones that they don't really talk about here, but it's a critical type of decision for a lot of other reasons too. And I don't know if you have any comments about it, or the governor want to weigh in on it.
Well, I would commend the decision to anyone who is interested in going through the rulemaking process, and because he does do such a good job of laying it out regardless of where you come down on the issue. One thing going back, now this is purely hypothetical because I don't see a difference in composition of the Rules Committee, but could the Administrative Rules Committee bring back this rule, for example, to go through a regulatory analysis? Is this not
resurrect a rule?
Well, to review a rule and perhaps change it.
Well, the regulatory analysis is, there's a limit on that. So they wouldn't be able to use a regulatory analysis. And a regulatory analysis hasn't been used. The last one I have seen was in 2011 on rules that were promulgated prior to Governor taking office. So those haven't been used. But there is a lifespan of when you can use them. The regulatory analysis usually is for noticed rules to come back before they're adopted and filed. But the Administrative Rules Review Committee can bring back and review any existing rule and then use other powers.
A rulemaking process that was utilized by Planned Parenthood in this case that we hadn't mentioned yet is the concise statement. And I think those are often overlooked. There are a couple of sentences tucked away in 17A.4 that authorizes any interested person prior to adoption of a rule or within 30 days after adoption to request a concise statement from the agency. And that has to include the principal reasons for and against the rule, and requires the agency to give reasons for overruling considerations in opposition to the rule. It has to issue at adoption or within 35 days after the request is received. It's useful for people who want to challenge a rule to get the agency to address specifically their reasons and address the reasons that people opposed it. And I don't know whether people don't find it in 17A.4. It's kind of buried, but it's a useful tool that, in my experience, isn't done very often. And I'd encourage people, if you're interested in challenging a rule, to ask agencies to go through that exercise.
Thank you. I'd like to, before we open it to questions, are there any further comments that we need to make, or?
Don't know if need to make, but a couple of things. A couple of things I'd say about administrative rules in general is, one, on the legislator's website, they do have a lot of material about it, administrative rules, and they come under a couple different tabs on the website. One of which I'd recommend anybody to look at is the legislative guide that the Legal Services Division puts out, which I think is on a publications or type site. But they do one, and it was done by Joe Royce, who was the attorney for the Administrative Rules Review Committee, who has been the attorney for that committee, I think, since probably the 70s. In any event, he produced a 34-page article that you can get from the website that explains the administrative rulemaking process. That's one that legislators look at to introduce themselves to the topic. I think it's a very valuable resource that I'd highly recommend anybody to obtain. Also on the legislative website, under the law, there's an administrative law section that has a lot of material about rulemaking, about emergency rules, about things that are filed on the rulemaking process, during the rulemaking process, and also some background information. Strongly recommend people to look at that. And again, to me, rulemaking, you've got statutes go into effect, but if they require rules, there's a secondary area that you need to be looking at and to address the concerns of your clients. And you can do that in a lot of different ways. One of them being in the actual rulemaking process, at the Administrative Rules Review Committee. That's a second, what I would consider jury that looks at it. The governor's office is another one that you can look at to try to get input on the rules during the rulemaking process. All three of those are viable, and they're different procedures, and you have to be aware of them and on the different places that you can have influence. I think that Christina has been one of the more successful people of exploring a lot of different ways that you can represent your client and at least foster their interests and at least get the important people to know about it. But there are numerous different avenues that you need to be exploring if you really want to be effective in your rulemaking and protecting Iowa's best interests in the rulemaking process. So those are some of my closing remarks before we get to questions.
You also showed me there is a list of the legislators' assistants who are involved in rulemaking that.
Yes, we have different things. I think we will be putting some things on the administrative law section website. But one of the things that might go up there is a list of the different people who are involved in the rulemaking process by agency, so that you can see who in particular is one of the contact person for the agency, and I think that probably has their phone number, that sort of contact information. But it's important to know who's involved in the rules at the agency, just so you can have the right input there too, besides just trying to go to the board or somebody to talk to at the agency.
It's also important to know who has the rulemaking authority, because in some agencies that board of commission is advisory only, and it's the department head that's doing the rulemaking. For example, the DOT, like the Transportation Commission, they're advisory on rulemaking, which kind of surprised me. They don't do the rulemaking. It's the DOT themselves that do the rulemaking. And so every agency is a little bit different as to who has that rulemaking authority as you work through it.
So please look at the Administrative Law Section's website. We will be putting either the documents or the links on it. One thing that comes through so clearly on the effectively representing your clients in the rulemaking process is how truly important legislatively the rulemaking process is and how it impacts our clients. And again, if you are working on that, the importance of registering as a lobbyist shouldn't be underemphasized. Please, are there any questions?
I would probably add on that lobbyist that most of the people Now, I would say that about half the people that came to the Administrative Rules Review Committee were not lobbyists. We've had lawyers that represented clients there that weren't lobbyists and talk on the rules. We've had lots of people come, that are just members of the industry that are being affected by rules come and talk. So you don't have to be a lobbyist to go to the Administrative Rules Review Committee and talk upon the rules. It's more if you're starting to advocate certain things that you get into the lobbyist type qualifications. They're something to be aware of, but they're not a necessity for presenting your case about a particular rule and its effect on your client or your industry, that sort of thing.
Yeah, testimony doesn't make you a lobbyist. It's when you call up the person in the agency that works on it and you make a suggestion to them, or you get involved with them on the rulemaking. But testifying at a public hearing, testifying for the Rules Review Committee, the testifying part is kind of really not, that's an exempt provision and not a definition of lobbyist. But pretty much everything else that a person would do to try to advocate would fall under that definition.
No questions at all?
No questions? Please.
Sorry, this is kind of a side issue, and maybe you don't want to address it, but we have had board members not to move out of state, but who otherwise they didn't meet the criteria anymore. They were appointed and they retired, or they changed jobs and the job they no longer met the description. And we've been advised that, they should stay in those positions and that they would be eligible to be appointed in the future. And I'm just wondering if that farm could address that.
I'd like to repeat your question first. And you mentioned that there are commissioners or members of boards who were on the board because they met specific qualifications, and that's how they were originally appointed to the board. And then over time, they lost whatever qualification they had by choice or otherwise. And you're asking whether the Farm Bureau opinion reached that, or what about these people? You've been told they're only not eligible for reappointment, but what about their continuing service on the board?
We'll go back and forth. Some of it depends on the ethics of the individual person who's serving and whether they feel comfortable still representing and serving on that, knowing what the qualifications were. In my experience, most folks self-recognize that, hey, I don't meet the qualifications, and they resign themselves. And that's historically, through the years that I've worked on it, that's mainly been the case. But that doesn't always happen. And so in that instance, they need to get legal advice as to whether their particular qualification would still meet the de facto officer doctrine. I think with the Farm Bureau case, the fact that someone's an Iowa elector means they're an Iowa resident and they are eligible to vote in Iowa. In that case, in the Farm Bureau case, the court said that wasn't a significant enough factor. That you don't have, that the de facto officer doctrine still applied in that instance. And so there are going to be, perhaps some narrow areas where that wouldn't apply, but the court in the Iowa Farm Bureau case did not set the limits of that de facto officer doctrine and did not establish limits to that doctrine. And so it probably would apply in most instances, but that's going to be up to probably an individual analysis of that particular situation.
I'm not sure I have much more to offer. Depending on how your statute is worded, and if you analogize to the EPC statutes, generally those kind of professional qualifications are not just qualifications for appointment. It means service, that you need to meet those kind of criteria. So it'd be unfortunate to have to rely on the de facto doctrine. The question has come up in the past that's somewhat related. There's political balance requirements by statute. Some people, we have open primaries. People can go in, maybe that's not the right term, go in and change party affiliation if they want to vote in a different primary. But they often change back. And I've said I don't think I'd get heartburn. If you had political balance and somebody changed party affiliation to vote. But some of the professional qualifications to serve on these boards, I'd be a little concerned if they stopped meeting them.
Has there been any instance where, unlike in your case, Christina, you knew in advance that X, Y, and Z were no longer qualified and they were challenged as continuing to sit? Do you recall any instances of that?
I've never run into the situation where they haven't just decided to resign, quite honestly. You know, at the EPC, for example, there was a manufacturing representative. When they were no longer employed by a manufacturer, they self-acknowledged and they decided that they were going to remove themselves from the board. And that's really highly been my experience, is that, you know, Iowans, you know, pretty much take care of that themselves when they're not meeting the qualifications.
Or if you're required to be an elector, Christina will suggest that you leave, register to vote in another state. But people, mostly they have to self-report because the public doesn't know if you've retired from a profession that's a credential.
And I don't think the decision actually said anything. Did it address whether or not this person was disqualified? Should have, okay.
Well, I think it was pretty, it was uncontroverted that she was no longer qualified as an elector.
Okay, but they didn't say whether she should resign or would be disqualified from continuing. That wasn't the question.
That wasn't the question.
The question was whether or not the action would have been overturned because of it.
Correct. Correct.
Actually, I think she had resigned before the litigation even got to district court.
Are there any other questions? Josh?
Yes. I'd be interested, given the experiences that the panelists had, to anticipate a need to challenge the rulemaking. What steps could you do during the rulemaking process to create the strongest record possible?
To repeat the question is, if you were going to challenge a rule, proposed rule, what is the most effective way to challenge it during the process?
To build the record.
To build your record to lead to an effective challenge.
I'd say in Iowa you don't need a whole lot of a record, because if your most successful challenges are they exceeding their statutory authority, and they either are or they aren't, and so that's not a situation where you establish a record. It's just that's an interpretation of law at that point. But everything else is a policy determination, and the courts generally don't get involved in those policy determinations. You know, those kinds of arguments are things you use to try to persuade the Rules Review Committee or the legislature or the governor's office, and those policy arguments are that you work to try to get that to occur during the rulemaking process. But from a legal basis for challenging it, you're really left with, did they have statutory authority to do it, and did they follow the rulemaking process correctly? There are some agencies that aren't, or boards that aren't as experienced with the rulemaking process, and sometimes they'll slip up, but that's very, very rare. So it's more, are they following the process, and did they have statutory authority to meet it? And neither one of those questions really involve establishing a record per se.
You might, you'd really like an objection from somebody, because it'll change the burden of proof. You should ask for a concise statement in the course of the rulemaking. You have a pretty narrow window to request that. Those would be good things to get lined up if you're planning for a fight legally and for a long haul in the courts.
Yeah, one of the lessons I think you need to draw is that contesting rules in court is a difficult process, and that the standards are pretty deferential to the agencies or to the people who are getting the rules, promulgating the rules. But there are very effective ways to try to combat it at different levels. That, for instance, at the agency itself, there are different avenues you can take. Contesting it at the Administrative Rules Review Committee, like I say, is a possibility, and that's one that should be explored more often. And I think bringing it to the governor, if you have a strong enough case, that, you can show some of the effects of the rule on Iowa's industry and these kind of things is another avenue. Taking it to the Attorney General's office is a little tough, as said, but all of those are different forums you can contest rules, and I think they're all very valid to go after. And the Administrative Rules Review Committee process, to me, the one that I'm most familiar with, there are so many different ways you can have input that should be explored. One of the things that was changed in the statute is to say that if it's going to have an effect of over $100,000, this sort of thing, there's supposed to be a fiscal note on it. And there are different kinds. The legislature used fiscal note in a couple different ways. In legislation, they have a fiscal note that says what's the cost to government, but the one in the administrative rules says the fiscal note is to judge the cost on all affected parties. Well, the agencies are not necessarily very effective at knowing what is going to cost the regulated industry. People should be having input on that cost to try to influence that fiscal note that comes out. You should be telling the agencies, these are the costs that are going to happen to my industry. Now, I've been around long enough to see that different governors and different, during the time period, the agencies have used that fiscal note in different ways, but quite often it ends up with the Legislative Service Agency, and the agency will say, well, we have no way of determining the cost to affected parties, so we don't know. And that gets related to the Legislative Service Agency, who then relates it to the Administrative Rules Review Committee, that we really don't know the cost to the affected parties. Well, that's an opportunity that's lost, because somebody should be able to tell you what it's going to cost my industry to have to live up to this rule. Now, that's an avenue that people should explore. Get that information to the agency, to the Legislative Service Agency, so that it ultimately gets to that decision-making body. It's less effective when you come with your letter and say that my business is going to suffer because of it. You could have done it at a fiscal note level and gone to everybody, and then it makes a bigger effect. So again, there are a lot of different ways that you can effectively fight the rules. Doing it in the courts is probably one of the more difficult.
And I just add, also earlier is better. Through the notice process, you can always change things. It's always, to ask for a change while the rule is noticed is easier than asking for an objection or a veto, a rescission, after the rule is adopted and filed. And so I think asking it as soon as the process begins, asking for what you want, if you know what it is, that's always the most effective way to do that.
Yeah, and the same goes, trying to get to the governor's office early and trying to get to the legislatures earlier is a better bet. There are a lot more flexibility, and informally, the governor's office and individual legislators can have an effect on agencies just by talking to them, or the Administrative Rules Review Committee can make some suggestions to the agency to talk to the industry more, which is regularly done, and most agencies will abide by that. If the governor's office says it needs more discussion with stakeholders, or if a legislator or this Administrative Rules Review Committee says it needs more discussion, normally an agency is going to follow up, because the consequences can be rather severe to it.
Is there a preference for, if you are objecting to a rule as it is noticed, that you give alternative language that would meet whatever objection you have? Do you want the language as part of the lobbying effort at that point?
That's a great question. I sat at a Rules Committee on this past Tuesday, or a week ago, and there's an issue on special education, and the board came up with a rule, and higher education came and objected to the rule. And the woman a professor from Drake came and she said, we acknowledge there's a problem. And she listed all the problems with the rule, and then after that, she listed 4 solutions. And you know, that was one of the most enlightening things to me, because I think in the governor's office, the legislature, you hear a lot of problems, in the attorney general's office, but you don't always hear solutions. And I think that's where Executive Order 80 comes, is we like solutions, that we can't always come up with the solutions, and we like to hear what the problems are, but we also like hearing the solutions. So as specific as you can get, what different language, other ideas, those are things that are very beneficial to our agencies, to the Rules Review Committee, to the governor's office, because then we can kind of come to a middle ground and find something there. And so I don't know what the rule will look like in the specific rule with the Board of Ed examiners, but I hope it comes somewhere in the middle, and you're not going to, you know, if you're just yelling, you know, we don't like it, and, you know, it's not going to really work. That's just kind of how it is. But if you say, no, we can live with that, and, you know, that's just kind of how it is. So I like that solution-oriented. This is in concrete, as concrete as you can get.
And I would say that's probably the exception in my experience there, that somebody actually had a proposed language or resolution to the rule problem. Most often they would just say, this is the part that's the biggest concern. And that's more effective than saying, I can't live with any of it. You know, if you can pinpoint the problem, that's always a little bit more effective. I would love to have people bring forward their language, but it was my experience that I did not get to see that very often. So I wouldn't let that stop you in trying to change something. Definitely pinpoint the problems that you can, but you don't necessarily have to propose language. It might be more effective if you do.
Thank you. Any other questions? We have a few more minutes. Roger? I'll try and repeat the question. If you have a problem with a proposed rule based on equal protection argument, when is the best time to raise that issue? Is that correct?
You know, that might be a good time to go to the Attorney General's office. If it's a rule that has not yet been noticed, or it's been noticed, that would be, I keep saying my former office. They would be interested if you thought you had legal reasons why the agency shouldn't proceed that way, and might relate that as advice to the agency. So I think there's a practical way to bring about those kind of legal concerns early in the rulemaking process, when their legal advisors can do something to turn the agency in a different direction.
Yeah, I think anytime there's a legal question, whether it's outside their statutory authority, or it's a constitutional question, whether it's, you know, equal protection or due process. Agencies also have their own legal counsel a lot of times, and so you don't necessarily have to go to the Attorney General's office, but sometimes if you talk to the agency's legal counsel, they will recognize the issue, you know, fairly quickly and try to fix it, because I think it's the agency's best interest to fix those kind of things so they don't end up in court.
And I'd have to agree that, you know, bringing it to the Administrative Rules Review Committee is advisable. I would not expect the Administrative Rules Review Committee to orally evaluate that, or to make comment about it. In the first place, they're not all lawyers, so it would have to be a pretty obvious equal protection argument, or they would have, you know, they wouldn't necessarily know about it, the background to know about it, but they do have an attorney on staff for the Administrative Rules Review Committee who can make an opinion about it if they want to have that opinion. But I do think it's important for them to be aware that it could be an issue, and that it's a pretty strong issue. So I think it's bringing it forward would be good. I'm not sure I remember any rules that in the 4 years that I was on the committee that we did anything for equal protection arguments other than generically we would be, I can imagine there are cases where we would say that the agency should be talking to somebody more and then going through more informal channels on it. But I'm sure I don't remember any objection because of equal protection arguments or anything this kind of thing. We would typically use just the language of the statute and say it's outside the scope, or we object because of arbitrary capricious, something of that nature.
Well, I'd like to thank you all for coming, and especially thank our great panelists.